The courtroom was smaller than Dorothy Martinez had imagined, with fluorescent lights that buzzed faintly and wooden benches that had been polished smooth by decades of nervous hands. She sat in the front row, her purse clutched in her lap, wearing the navy blue dress she'd worn to her granddaughter's wedding 3 years ago because it was the nicest thing she owned. At 89 years old, with arthritis in both hands and a hearing aid that whistled when she turned her head too quickly, Dorothy had never been inside a courtroom before. Never had a reason to be. She'd paid her bills on time her whole life. Never owed anyone anything she couldn't pay back. Never caused trouble. And now she was being sued for $17,643 plus interest and legal fees for a credit card debt she swore she'd never incurred. The lawyer representing the collection agency sat at the plaintiff's table, shuffling papers with the bored efficiency of someone who'd done this 1,000 times before. And the judge, a woman named Patricia O'Connor, who'd been on the bench for 19 years, looked down at the case file with an expression that started as routine and patience, but would, over the course of the next 47 minutes, transform into something much harder to define. Something between fury and heartbreak. Because what Judge O'Connor was about to uncover wasn't just a mistake. It was a machine, a system designed to extract money from people who couldn't fight back. And Dorothy Martinez, who'd come to court expecting to lose everything, was about to become the wrench that broke it. 2 years earlier, Dorothy's wife had a rhythm to it, the kind of comfortable predictability that comes from 8 decades of living in the same place and knowing exactly who you are. She lived in a small apartment on the second floor of a building that had been new when Kennedy was president and was now just old. The rent was $780 a month, which she could afford on her Social Security check of $1,043 if she was careful. And Dorothy had spent her entire life being careful. She'd worked for 42 years as a school cafeteria worker, serving lunch to generations of children who barely noticed her, but who she remembered by name years later when she'd see them grown up with kids of their own. She'd raised 3 children alone after her husband died in a construction accident when the youngest was still in diapers. She'd done it without government assistance, without handouts, without asking anyone for help, because that's not how she was raised. You worked. You saved, you lived within your means, and if you didn't have money for something, you didn't buy it. Dorothy didn't have a credit card, never wanted one, never saw the point. If she couldn't afford to pay cash for something, then she couldn't afford it, period. She had a checking account at the credit union where she'd banked for 53 years. She had a savings account with $4,200 in it, money she'd scraped together over decades for emergencies. And she had her routines. Monday was grocery shopping. Tuesday was laundry in the building's basement. Wednesday, she volunteered at the church food pantry. Thursday was doctor's appointments, if she had any, or visiting her friend Lucille if she didn't. Friday through Sunday belonged to her children and grandchildren, whoever had time to visit or call. She didn't use computers, didn't have internet, didn't own a cell phone because the monthly bill seemed excessive when she had a perfectly good landline that cost $19 a month. Her grandson Miguel had tried to teach her how to use email once, setting her up with an account and showing her how to click and type, but it all seemed too complicated. And she'd forgotten the password by the next day anyway. She paid her bills the old-fashioned way, checks in envelopes with stamps. She kept every receipt in a shoebox organized by month. She balanced her checkbook by hand every Sunday night after dinner, the way she'd been doing since 1963. In September, Dorothy received a letter. It came in a white envelope with a return address from a company called Apex Recovery Solutions. She opened it at her kitchen table, read it twice, and felt her heart start to pound in a way that scared her. The letter said she owed $17,643 on a credit card account that had been charged off and sold to their collection agency. It said the original creditor was United Financial Services. It said the debt was from 2019. It said if she didn't pay within 30 days, they would pursue legal action.
Dorothy read the letter a third time, trying to make sense of it. She didn't have a credit card with United Financial Services, didn't have a credit card with anyone. The only card she had was her debit card from the credit union, and that just accessed her own checking account. This had to be a mistake. Had to be. She called the number on the letter. The person who answered sounded young and impatient, talking fast in a way that made Dorothy struggle to keep up. She explained that she didn't owe this money, that she'd never had a credit card with United Financial Services, that there must be some kind of error. The person on the phone said the debt was valid, that it had been verified, that Dorothy needed to pay. Dorothy said again, more firmly this time, that she didn't owe this money. The person said if she didn't pay, they'd garnish her wages or put a lien on her property. Dorothy said she didn't have wages to garnish or property to lien. She was 89 years old, living on Social Security. The person said then they'd sue her, and hung up. Dorothy sat at her kitchen table for a long time after that call, the letter in her shaking hands, trying to figure out what to do. She called her daughter Alina, who lived 40 minutes away and worked as a nurse. Alina was furious, said this sounded like a scam, said, "Mom, don't pay them anything. We'll figure this out." Alina came over that evening and looked at the letter, Googled Apex Recovery Solutions on her phone, found hundreds of complaints online, people saying the company was harassing them over debts they didn't know, people saying they were being sued for things that weren't real. Alina said, "Mom, you need to write them a letter. Tell them you're disputing the debt. Tell them to prove you owe it." So Dorothy did. She wrote a letter by hand, her arthritis making the writing slow and shaky, explaining that she didn't have a credit card, had never had a credit card with United Financial Services, and was formally disputing this debt. She asked them to provide proof that the debt was hers. She made a copy at the library for 50 cents, sent the original certified mail so she'd have proof they received it. Then she waited. Nothing happened for 6 weeks. Dorothy started to think maybe it had been resolved. Maybe they'd realized their mistake and were correcting it. But then in early November, another letter came. This one was from a law firm called Baxter & Green, representing Apex Recovery Solutions. It said they were filing a lawsuit against her for the $17,643, plus interest, plus attorney's fees, plus court costs. It said she'd been served. It said she had 30 days to respond or a default judgment would be entered against her. Dorothy's hands shook so badly she could barely hold the letter. She called Alina, crying for the first time in years, saying she didn't understand what was happening, didn't know what to do. Alina came over immediately, read the lawsuit, called a lawyer she knew from the hospital who did some civil work. The lawyer said Dorothy needed to file a response, that if she didn't, she'd lose automatically. But the lawyer also said he didn't handle this kind of case and didn't know anyone who did, especially not for someone who couldn't afford to pay. He suggested contacting legal aid. Alina called every legal aid organization in the county. All of them said the same thing. They were overwhelmed, understaffed, had waiting lists months long, and debt collection cases weren't a priority when they had people facing evictions and domestic violence and child custody battles. One paralegal, sounding genuinely sorry, said, "Honestly, your best bet is just to show up in court and explain to the judge that she doesn't owe this. Sometimes judges will dismiss these cases if the debt collector can't prove the debt." So that became the plan. Dorothy would go to court, tell the truth, and hope the judge believed her. But Dorothy was terrified. She didn't sleep well for weeks leading up to the court date. She kept thinking about what the person on the phone had said about garnishing wages and liens and lawsuits. She didn't have wages, but she had her Social Security check. Could they take that? Could they take her savings account? Could they force her out of her apartment? She didn't know. And not knowing was worse than anything. The night before the hearing, Alina came over and helped Dorothy pick out what to wear, helped her organize her documents, the letter disputing the debt, the certified mail receipt, her bank statements showing she'd never made payments to United Financial Services, every piece of paper Dorothy could find that proved she was telling the truth. Alina offered to come to court with her, but she had a shift at the hospital she couldn't miss. So Dorothy's son, Carlos, who'd taken the morning off work, drove her downtown to the courthouse. The courthouse was a massive stone building that made Dorothy feel small. Carlos walked her through security, through the metal detector that beeped because of the pins in her hip from a fall 10 years ago, up to the 3rd floor where the civil courtroom was located. They sat on a bench outside until her case was called.
Dorothy watched other people go in and out, most of them looking as nervous and lost as she felt. When the bailiff called her name, Carlos squeezed her hand and said, "Just tell the truth, Mom. That's all you can do." Dorothy walked into the courtroom, her legs unsteady, and took her seat. Judge Patricia O'Connor was 57 years old, with gray hair pulled back in a neat bun and reading glasses that sat low on her nose. She'd been a judge long enough to recognize patterns, and one pattern she'd seen increasingly over the past few years was debt collection cases that didn't quite add up. Cases where the documentation was thin, where the plaintiff's lawyer couldn't answer basic questions about the debt, where the defendants were elderly or poor or both, people who didn't have lawyers, people who barely understood why they were in court. She looked at the case file in front of her. Dorothy Martinez, 89 years old, sued by Apex Recovery Solutions for $17,000. No attorney representing the defendant. Judge O'Connor had seen this scenario dozens of times. Usually, it ended with a default judgment because the defendant didn't show up, didn't know how to respond, didn't understand the system. But Dorothy had shown up, and that meant Judge O'Connor had to actually examine the case. The lawyer for Apex Recovery Solutions stood up. His name was Brian Kelsey, and he was 34 years old and worked for a firm that did nothing but debt collection litigation. He filed 30 to 40 lawsuits a week. Most of them settled. Most of the defendants never showed up. This was supposed to be quick. He began his presentation, said that Dorothy Martinez owed $17,643 to his client for a credit card debt that had been charged off and purchased from the original creditor, said they had documentation, said they were seeking a judgment for the full amount plus interest and fees. Judge O'Connor looked at Dorothy. "Ms. Martinez, do you have representation?" "No, Your Honor," Dorothy said. Her voice so quiet the judge had to ask her to speak up. "And what's your response to this lawsuit?" Dorothy stood up slowly, gripping the edge of the table to steady herself. "Your Honor, I don't owe this money. I've never had a credit card with United Financial Services. I've never had a credit card with anyone. I don't use credit cards. I don't even know what United Financial Services is." Judge O'Connor turned to the lawyer. "Mr. Kelsey, does your client have documentation showing that Dorothy Martinez opened this account and incurred this debt?" "We have an affidavit from the original creditor stating that the debt is valid." Kelsey pulled a paper from his file. "May I see it?" Kelsey approached the bench and handed the document to Judge O'Connor. She read it. It was one page, printed on letterhead from United Financial Services. It said that Dorothy Martinez had opened an account in April 2019, had made charges totaling $17,000, had stopped making payments in August 2019, and the account had been charged off and sold to Apex Recovery Solutions in January of the previous year. It was signed by someone named Rebecca Thornton, Vice President of Collections. Judge O'Connor looked up. "This is the only documentation you have?" "Yes, Your Honor. The affidavit confirms the debt." "Do you have the original credit card application? Do you have statements showing the charges? Do you have any documentation beyond this single affidavit?" Kelsey shifted uncomfortably. "The debt was purchased from the original creditor. We received the account information and the affidavit confirming validity. That's standard in these transactions." Judge O'Connor took off her glasses. She'd heard this before. Debt buyers purchasing portfolios of charged-off debt for pennies on the dollar, then suing people based on nothing more than a computerized list and a boilerplate affidavit. No verification, no investigation, just volume. File as many lawsuits as possible, get default judgments, garnish wages or bank accounts, move on to the next case. She looked at Dorothy. "Ms. Martinez, did you ever receive credit card statements from United Financial Services?" "No, Your Honor." "Did anyone from United Financial Services or from Apex Recovery Solutions ever provide you with documentation of this debt before filing the lawsuit?" "No, Your Honor. I got a letter saying I owed money,
And I wrote back saying I didn't, and then I got sued. Judge O'Connor turned back to Kelsey. Mr. Kelsey, you're asking this court to enter a judgment for $17,000 against an 89-year-old woman living on Social Security based solely on an affidavit. No original contract, no account statements, no payment history, just an affidavit? Your Honor, the affidavit is sufficient under... No, Judge O'Connor said, her voice sharp. It's not. Not in my courtroom. The room went very quiet. Judge O'Connor leaned forward. Mr. Kelsey, I'm going to ask you some very specific questions, and I want truthful answers. How many of these cases has your firm filed in the past year? Kelsey hesitated. I'd have to check the exact number, Your Honor. Estimate. Maybe 1,500. 1,500 debt collection lawsuits. And in how many of those cases did the defendant have legal representation? I couldn't say exactly. Estimate. Maybe 10%? So in approximately 1,300 cases, you were suing people who had no lawyer, people who probably don't understand the legal system, people who probably can't afford to defend themselves. And in how many of those cases did you actually have documentation beyond an affidavit? Kelsey didn't answer. Mr. Kelsey, I asked you a question. Your Honor, the documentation varies by case. The affidavits are provided by the creditors and represent... Have you personally verified any of these debts? Have you ever contacted the original creditor to confirm the information in the affidavits? Have you ever investigated whether the person you're suing actually owes this money? Your Honor, we rely on the information provided to us by our client, which is standard practice. And standard practice, Judge O'Connor repeated. Standard practice is to file lawsuits against people without verifying the claims. Standard practice is to rely on affidavits that may or may not be accurate. Standard practice is to flood the courts with cases, hoping most defendants won't show up so you can get default judgments. Is that what you're telling me? Kelsey's face had gone red. Your Honor, we operate within the bounds of the law. Judge O'Connor sat back in her chair. She was angry now. The kind of anger that comes from seeing injustice repeat itself over and over until it stops looking like individual failures and starts looking like systemic abuse. She'd seen too many cases like this, too many elderly people, too many poor people, too many vulnerable people being sued for debts they might not owe by companies that couldn't be bothered to verify their claims. And most of those people never made it to court, never fought back. Just let the default judgments happen and spend the rest of their lives having their wages garnished or their bank accounts seized. But Dorothy showed up, and that gave Judge O'Connor the opportunity to do something about it. Ms. Martinez, did you write a letter to Apex Recovery Solutions disputing this debt? Yes, Your Honor. I sent it certified mail. Dorothy pulled a paper from her folder, the receipt from the post office. And they sued you anyway. Yes, Your Honor.
Judge O'Connor looked at Kelsey. Mr. Kelsey, under the Fair Debt Collection Practices Act, when a consumer disputes a debt in writing, the debt collector is required to provide verification of the debt. Did your client provide verification to Ms. Martinez? Your Honor, the lawsuit itself serves as no, it doesn't. The law is very clear. When a debt is disputed, you must provide verification before pursuing collection. You didn't do that. You went straight to filing a lawsuit. Kelsey was scrambling now. Your Honor, if we could have a continuance to gather additional documentation? No, Judge O'Connor said. You've had 2 years to gather documentation. You filed this lawsuit without proper verification. You're asking this court to enter a judgment that could devastate this woman's life, and you don't even have basic proof that she owes this money. She picked up her pen. I'm dismissing this case with prejudice, which means it cannot be refiled. Dorothy felt something release in her chest,
a pressure she'd been holding for months. She wasn't sure what "with prejudice" meant, but it sounded final. It sounded like winning. But Judge O'Connor wasn't done. "Mr. Kelsey, I'm also finding that your client violated the Fair Debt Collection Practices Act by filing this lawsuit without proper verification. I'm ordering Apex Recovery Solutions to pay Miss Martinez's costs, and I'm referring this matter to the State Attorney General's office for investigation into your firm's practices." Kelsey looked like he'd been hit. "Your Honor, I don't think that's—" "You don't have to think, Mr. Kelsey. I've made my ruling. This case is dismissed." Judge O'Connor banged her gavel, and just like that, it was over. Dorothy walked out of that courtroom feeling lighter than she had in months. Carlos was waiting outside, and when she told him what happened, he hugged her so hard her ribs hurt. Elena cried when they called her, and that night, Dorothy slept better than she had since September. But the story didn't end there, because Judge O'Connor kept her word. She sent a detailed letter to the State Attorney General's office outlining what she'd seen in her courtroom. Not just Dorothy's case, but the pattern of cases. The 1,500 lawsuits filed by one firm in 1 year, the lack of documentation, the targeting of vulnerable populations, the systematic abuse of the legal system to extract money from people who couldn't defend themselves. The Attorney General's office opened an investigation. They subpoenaed records from Baxter and Green, from Apex Recovery Solutions, from United Financial Services. And what they found was staggering. Apex Recovery Solutions had purchased portfolios of charged-off debt, tens of thousands of accounts, for a fraction of their supposed value. They then filed lawsuits against thousands of people, mostly elderly or low income, based on nothing more than a list of names and numbers. They didn't verify the debts, didn't investigate whether the people actually owed the money, just filed suit, hoped for default judgments, and collected whatever they could. In Dorothy's case specifically, they discovered something even worse. The debt wasn't just unverified, it was fraudulent. Someone had stolen Dorothy's identity in 2019, opened a credit card in her name, made charges, and then disappeared. United Financial Services had never properly investigated the fraud, had just charged off the account and sold it to a debt buyer. And that debt buyer had sued Dorothy without ever checking whether she'd actually opened the account. The Attorney General filed charges, not just against Apex Recovery Solutions, but against Baxter and Green for filing lawsuits they knew or should have known were based on insufficient evidence. The case became a landmark. The state passed new regulations requiring debt buyers to verify debts before filing lawsuits, requiring actual documentation, not just affidavits, requiring proof that the person being sued actually owed the money. And Dorothy, who'd just been trying to defend herself, became the face of a movement. Legal aid organizations started using her case as an example in trainings, teaching people that they could fight back, that they could go to court, that judges would listen if they just showed up and told the truth. A lawyer named Michelle Torres, who specialized in consumer protection, reached out to Dorothy, said she wanted to file a lawsuit on Dorothy's behalf against Apex Recovery Solutions for violating the Fair Debt Collection Practices Act, for the harassment, for the emotional distress, for filing a lawsuit based on fraudulent debt. Dorothy didn't want more legal trouble, didn't want more stress, but Elena convinced her, said, "Mom, this isn't just about you anymore. This is about everyone else they've done this to." So Dorothy agreed. Michelle Torres filed the lawsuit, and 18 months later, after depositions and discovery and negotiations, Apex Recovery Solutions settled. They paid Dorothy $75,000. They also agreed to cease operations, to stop filing debt collection lawsuits entirely, and they agreed to a fund that would compensate other victims of their practices. Dorothy used some of that money to move to a nicer apartment, one with an elevator so she didn't have to climb stairs anymore. She gave some to her children, put some in savings, and donated $20,000 to the legal aid organization that had helped train her lawyer. so they could help other people fight back. Judge Patricia O'Connor retired 2 years later, and at her retirement ceremony, she talked about Dorothy's case, about how one woman showing up, one woman refusing to back down, had exposed a system that was broken, had led to reforms that protected thousands of people. She said, "The law is supposed to protect the vulnerable, not prey on them, and when it fails to do that, it's our job to fix it." Dorothy lived to be 93. She spent her final years comfortable, secure, surrounded by her children and grandchildren who told everyone about the time their grandmother took on a debt collection agency and won. And when she died, peacefully in her sleep on a Sunday morning after church, the obituary mentioned that she'd been a cafeteria worker, a mother, a grandmother, and an advocate who changed the law by simply telling the truth. At her funeral, Michelle Torres stood up and said something that captured what Dorothy's fight had meant. She said, "Dorothy Martinez didn't set out to be a hero. She just refused to accept an injustice. And sometimes that's all it takes. One person saying no. One person standing up. One person believing their voice matters. Because it does. It always does." If you want more stories about ordinary people who stood up to powerful systems and won, feel free to like this video. Make sure to subscribe so you don't miss the next story. And here's my question for you. Have you or someone you love ever been contacted by a debt collector for something you didn't owe? What did you do? Would you have had the courage to go to court like Dorothy did? Share your thoughts in the comments below, because these stories matter, your experiences matter, and the only way we protect each other is by speaking up and standing together.